Good evening. I welcome my brothers and sisters. I welcome teachers and trainers. I welcome professors, professionals. I welcome listeners and learners. I welcome respected doctors and directors. I welcome adorable ministers and managers. I welcome honorable advocates, advertisers, administrators and advisors. I, Dr. Rakesh from USA, heartily, cordially welcome the most honorable President Counsellor Modi ji. It is really nice time, nice space, nice section today that we are appreciating our holy cultural identities in the form of literary features. Write a short note on the nature of the Indian Constitution. Our Indian Constitution is also the part of the literature. The literature of the different countries were read, collected, and researched by Baba Sahib Dr. Bimla Ambedkar. Then ultimately it was prepared in the form of nature. Write a short note on the nature of the Indian Constitution. Constitutional scholars have divided the Constitution into two categories. One is Federal Constitution. In this, there is division of powers between the center and the states. This division is done in such a way that everyone is completely independent in their own field, and at the same time they are cooperative with each other and not subordinate to each other. Following are the essential elements of the Federal Constitution. One is written Constitution, with supremacy of the Constitution. Three is immutability of the Constitution. Four is division of powers and authority of the judiciary. What is unitary Constitution? In this, all the powers are vested in a single government, which is usually the central government. The provinces have to remain under the central government. The main characteristics of a unitary constitution are as follows. Creation of new states and power to change the areas. establish a strong and powerful center which would be capable of stopping external attacks on the country at any time and would be fully capable of suppressing internal destructive elements. To achieve this goal, the central government has been given more powers than the state governments. The Indian federal system is a changeable system, and as per requirement, it can take either federal or unity from federal or unity form. Generally, its form remains federal, but in times of crisis, from the point of view of national unity and security, such provisions have been included which convert it into a unity structure. In the case of S.R. Bomai versus Union of India, 1994, was held by majority that the Indian Constitution is a federal constitution and federalism is the basic structure of the constitution. Justice Shri Sawant and Shri Kuldeep Singh have said that federalism prevails in the Indian constitution and it has not ended in any way. Despite the fact there are provisions in the constitution under which the center has been given overriding power over the states. Yet our constitution is federal. This means that the state is sovereign within its perimeter or territory. In conclusion, it can be said in brief that Constitution of India is neither purely federal nor purely unitary, but it is a combination of both. For example, it is semi-federal. This is a unique constitution of its kind. It recognizes the principle that national interest is paramount rather than the federal principle. Professor Weir also calls the Indian Constitution a semi-federal constitution, whereas Professor Jennings has called the Indian Constitution a federation which has a strong tendency of centralization. Let us state the main characteristics of the Constitution of India. One is world's largest constitution, two is written constitution, three is incorporation of constitution of different countries in the Indian Constitution. Four is preamble of the Constitution. Five is dominant. Six is democratic. Seven is socialist system. Eight is parliamentary government. 9 is fundamental rights, and 10 is directive principles of state policy. 11 is coordination of stiffness and flexibility, and 12 is powerful center. 13 is independent judiciary. 14 is adult franchising. 15 is fundamental duties, and 16 is establishment of secular state. 17 is single citizenship. Let us state the essential elements. Let us state the essential elements. Let us state the essential elements of the federal constitution. Following are the essential elements of a federal constitution. One is distribution of powers. One is distribution of powers. Division of powers between the center and the states is an essential element of the federal constitution. This division is done by the constitution itself. Every government is sworn in its own territory and cannot encroach on the rights and powers of others. Thus, in federalism, the powers of the state are decentralized among many cooperative institutions. The source of all organs of government is the constitution, which controls the exercise of their powers. What is supremacy of the constitution? The constitution is the source of all organs of the government, executive, legislative, and judiciary. All provisions related to their form, organization, and powers are contained in the Constitution itself. The Constitution sets the limits of their jurisdiction within which they function. All institutions work under the control of the Constitution. In a federal system, the Constitution is considered to be the supreme law of the country. According to Professor Hewer, the primacy of the Constitution is very important for the federal government and for its smooth functioning. It is also necessary for the Constitution to be written. The source of legislative power of the central and provincial legislature is the Constitution itself and is made by them. Laws are subject to the Constitution. If they go against the provisions of the Constitution, the court can declare them illegal. Similarly, they have to use all their rights and powers granted by the Constitution within the limits set by the Constitution. What is the written Constitution? The federal Constitution is essential. A federal Constitution is essentially a written Constitution. The establishment of a union state is established by a complex contract in which the units join the union only on certain conditions. It is necessary for these conditions to be returned. Otherwise, it would be impossible. Otherwise, it would be impossible to keep the supremacy of the Constitution intact. Basing such a system on compromise and tradition will definitely create doubts and differences. Due to the written constitution, both the central and provincial governments are clearly aware of their respective rights and they work with trust in each other. Variability of the constitution. What is the variability of the constitution? The written constitution is naturally inflexible. It is also necessary for the supreme law of the country to be inflexible. The flexibility and inflexibility of the constitution depends on the process of its amendment. The process of amendment in the constitution is difficult. It is called an inflexible constitution, and in which amendments can be made easily. It is called a flexible constitution. The constitution of any country is a permanent document. It is said to be the supreme law of the country. To maintain the supremacy of the constitution, the process of amendment needs to be difficult. This does not mean that the constitution should be immutable, but only those changes can be made in the constitution which are necessary according to the time and circumstances. Authority of courts. In the federal constitution, there is a division of powers between the central and provincial governments. This division is done by a written constitution. Hence, it is necessary that this division of powers be maintained so that the central and state governments should be encroached on each other's jurisdiction. Since the division of government powers is done through a written document, it is possible that different governments can interpret the provisions of the constitution in their own favor. In such a situation, to interpret them correctly, an institution is required which is independent and impartial. This function has been assigned to the judiciary in the federal constitution. Only the judiciary has the authority to give the final decision regarding the interpretation of the provisions of the constitution. This institution is not subordinate to any government. It performs its function as a completely independent and impartial institution, as a third part of the government in a federal system. The great task of protecting the supremacy of the constitution rests with the judiciary. The interpretation of the constitution made by the judiciary is binding on all authorities. Right? Let us write a short note on protection from ex post facto law. Clause 1 of Article 20 provides that no person shall be convicted only of an offence prescribed under any law in forces and not of any other offence. Nor shall he be liable to any punishment greater than that which would be punishable under the law in force at the time of the commission of the offence. Ex post facto law is a law which is made after the commission of a crime and declares an act as a crime, which was not a crime when it was committed or increases the amount of punishment in the law in force. Generally, the legislature can make both retrospective and prospective laws. Article 20 prohibits making only penal laws. It does not prohibit civil laws from being given retrospective effect. For example, taxes can be levied retrospectively. The first part of clause 1 provides that no person shall be punished for any offence other than mere contravention of any law in force. This means that if an act was not a crime at the time it was committed, it cannot be declared a crime later. The case of Farid versus Nidambarana, AIR 1967, Kerala 155 is a good example. According to the law applicable at that time, not paying panchayat tax was not a crime. Later, a law was passed declaring it a crime. The Kerala High Court ruled that the law passed later was unconstitutional. It provides protection only against conviction under retrospective laws and also against trial thereunder. Therefore, if someone is tried under a procedure different from the prevailing law or by special court, then according to the Indian Constitution, it will not be unconstitutional. In short, in the prevailing law, the prevailing procedure can be changed later or a completely new procedure can be prescribed. But in cases involving preventive detention or non-grant of bail, the protection of this section is not available. The second part of clause 1 prohibits increasing the amount of punishment prescribed in any law in force. That is, no person shall be eligible for more punishment than that which could have been given under any law in force at the time of the commission of that offence. In the case of Kedarnath versus State of West Bengal, AIR 1953 SC 177, the accused had committed an offence in the year 1947 under the law applicable at that time. The law applicable at that time, imprisonment or fine or both could be given for that crime. The said act was amended in 1949 and the punishment for that crime was increased. According to this, arrangements were made to confiscate the money paid as additional penalty. The Supreme Court ruled that punishment could not be given in 1949 for a crime committed in 1947 and ordered reduction of the increased fine. State the preamble of Indian Constitution. Let us state the preamble of the Constitution. We, the people of India, having solemnly resolved to constitute India into a swan socialist secular democratic republic and to secure to all its citizens justice, social, economic and political, liberty of thought, expression, belief, faith and worship, equality of status and opportunity, and to promote among them all fraternity, assuring the dignity of the individual and the unity and integrity of the nation in our Constituent Assembly this 26th day of November 1949 do hereby adopt, enact and give to ourselves this Constitution. Let us explain the importance of the preamble of Indian Constitution. The preamble plays a very important role in shaping the destiny of the country. The preamble gives a brief idea to the makers of the Constitution, so that the Constituent Assembly make plans and formulates the Constitution. The only question raised about the scope of the preamble is whether it is a part of the Indian Constitution or not. The answer to this question is dealt later in this article. But the main purpose of the preamble is to clarify the idea behind the Constitution. For example, what is the source? What are the ultimate goals and objectives behind it? Arguments regarding the status of preamble. Whether preamble is a part of the Constitution. It has been a matter of argument and discussion that whether the preamble is a part of the Constitution or not. There are two cases that provide the idea about the status of the preamble. Re-Baruberi case. Under this case, the 8th Judicial Bench observed that even though the preamble serves as an introduction to the Constitution, and no doubt it is a concept which opens the mind of the makers and helps them in making a Constitution, that does not mean that the preamble is a part of the Constitution. Keshavananda Bharati case. The case creates a new history of the Constitution. The 13 judges bench held that preamble is a part of the Constitution itself. As the preamble is an introduction of the Constitution, the preamble is not a source of powers, but played an important role in the interpretation of the statutes. Whether preamble can be amended. Whether the preamble can be amended under Article 368 or not. The evolution of opinion on this issue can be seen through the following landmark developments. Keshavananda Bharati case, 1973. In this case, the Supreme Court held that preamble is a part of the Constitution and hence can be amended subject to the condition that no amendment is done to the basic structure of the Constitution. Amendment to the preamble. The preamble to the Constitution has been amended only once by 42nd Constitutional Amendment Act of 1976. The amendment, which was made based on the recommendations of the recommendations based on the Sardar Swan Singh Committee added three new words: socialist, secular, and integrity to the existing preamble. Socialist and secular were added between Swan and democratic. Unity of the nation was changed to unity and integrity of the nation. The preamble of Indian Constitution serves as a foundational document and guiding light that outlines the objectives of the whole Constitution. It's a declaration that acts as a fountainhead of wisdom for the Constitution of India. Therefore, while making a law, lawmakers have to examine it on the threshold of the preamble of the Constitution. Let us explain secularism. Secularism means that the state has no religion of its own and neither supports nor opposes any religion. In other words, the state is neutral in matters of religion. The Indian Constitution establishes a secular state in India in which the state has no religion of its own. The government does not promote any particular religion. The state is completely neutral in matters of religion. The state neither declares any religion nor disrespects any religion, but respects every religion equally. Every citizen in India has the freedom to follow any religion and worship in any way according to his or her belief. Freedom of religion is not limited only to religious belief, but it also includes the right to propaganda and disseminate it. Article 25 to 28. The preamble of the Constitution was also amended by the 42nd Constitutional Amendment Act 1976 and the word secular was added. However, there was no need for this because the provisions related to this were already in the original Constitution. Let us state the provision to citizen in India in Indian Constitution. Article 5, citizenship at the commencement of the Constitution. This article talks about citizenship for people at the commencement of the Constitution. For example, 26 January 1950. Under this, citizenship is conferred upon those persons who have their domicile in Indian territory and who was born in Indian territory or whose either parent was born in Indian territory or who has ordinarily been a resident of India for not less than 5 years immediately preceding the commencement of the Constitution. Article 6. Citizenship. Citizenship of certain persons who have migrated from Pakistan. Any person who has migrated from Pakistan shall be a citizen of India at the time of the commencement of the Constitution. Article 7. Citizen of certain migrants to Pakistan. This article deals with the rights of the people. This article deals with the rights of the people who had migrated to Pakistan after March 1, 1947, but subsequently returned to India. Article 8. Citizenship of certain persons of Indian origin residing outside India. This article deals with the rights of people of Indian origin residing outside India for purposes of employment, marriage, and education. Article 9. People voluntarily acquiring citizenship of a foreign country will not be citizens of India. Article 10. Any person who is considered a citizen of India under any way of the provisions of this part shall continue to the citizens and will also be subject to any law made by the Parliament. Article 11. Parliament to regulate the right of citizenship by law. The Parliament has the right to make any provision concerning the acquisition and termination of citizenship and any other matter relating to citizenship. Let us state the provisions regarding establishment of new states and alterations of name and boundaries of existing states. Under Article 2 of the Constitution, Parliament can admit or establish new states into the Union with such restriction and condition as it thinks fit. Thus, under Article 2, Parliament has two types of powers. First, the power to include new states in the Union. Second, the power to establish new states. The first is related to those states which already exist, and the second is related to those states which can be established or required in the future. It is noteworthy that the entry or establishment of the new state will be done according to such restriction or condition as the Parliament deems appropriate. Similarly, under Article 3, Parliament has the power to establish new states and change the areas, boundaries, or names of existing states. Under this article, states can be established in the following ways. One, by separating its territory from an existing state, or by combining two or more states, or three, by combining parts of a state, or by merging a region with a state. Under Article 3, Parliament can decrease the area of a state, change its boundaries, and change the name of the state. Here, the word state also includes union territory. It is appropriate to mention here that after approving a new state or making changes in the boundary of the existing state, the Parliament can make necessary changes in the Constitution by simple majority to make it effective. No law passed by Parliament for the accomplishment of this purpose shall be deemed to be an amendment of the Constitution for the purpose of Article 368, Article 4. Let us think short note on judicial review. Any law which is inconsistent with or abridges the fundamental rights in force in Indian immediately before the coming into the force of the Constitution shall be void according to Article 13I to the extent to which it is inconsistent with or abridging the fundamental rights. Subclause 2 of the Article 13 provides that the state shall not make any law which takes away or abridges the rights confirmed by Part 3 and declares that every law wherein contravention of this clause shall be punishable to the extent of the contravention. The word law used in subsection 2 has been used in a very broad sense. Subclause 3 says that it includes any ordinance, order, by law, rule by law, notification, custom or usage having the force of law in India. Thus, if fundamental rights are infringed by any law or by law or executive order, then its validity can be challenged in the court. In fact, Article 13 is the foundation of fundamental rights. It provides the courts with the power to declare laws inconsistent with fundamental rights as illegal. This makes the Supreme Court the sentinel of the fundamental rights of the citizens. This power of the court is called judicial review. Power of judicial review, in fact, Article 13 of the Constitution gives the power of judicial review to the courts. This power has been given only to the Supreme Court, Article 32, and High Court, Article 226. Under this power, the Supreme Court and the High Court can declare as unconstitutional any act passed by the legislature which is inconsistent with any provision given in Part 3 of the Constitution. What is the meaning of judicial review? According to Professor Carvin, the power of judicial review is the power of the courts under which they examine the constitutionality of the acts passed by the legislature. They may refuse to give effect to any law which is inconsistent with any provision contained in Part 3 of the Constitution. This law comes under the general jurisdiction of the courts. The history of human development is witness to the fact that when a person gets unlimited powers, he becomes corrupt. Its use leads to oppression and chaos in the society. Efforts are always being made to limit this power of man, and for this purpose, such institutions have been established which can curb the misuse of this power. The problem becomes even more difficult when the government starts acting arbitrarily. French philosopher Montesquieu had propounded the principle of separation of powers with the aim of curbing the unrestricted and uncontrolled power of all organs of the government. The cabinet, the combined name of legislature, executive, and judiciary is called government. These are the powers under the government according to this principle. Separation of these three powers is necessary. It is necessary that one power of the state should not interfere in the operation of another power, and that each organ should work within its limits, and that all powers should not be centralized in any organ of the government. Only by establishing a balance among these powers can the arbitrary and autocratic nature of man be controlled, and the freedoms granted by the Constitution can be protected. This division is called the principle of separation of powers. Thus, judicial review is the power to control the exercise of the powers of the legislature, executive, and judiciary. The concept of judicial review originates from the theory of limited power government. According to this principle, there are two types of law. One is ordinary law and the other is supreme law. For example, constitutional law is the base source of other laws. Any law which infringes or violates the provisions of the Constitution will be considered unconstitutional. In such a situation, some institution should have the authority to declare these laws invalid, and this organ is undoubtedly the judiciary. Let us explain the reasonable classification under Article 14. Article 14 of the Constitution talks about equality before law and equal protection of law, but it does not mean that every law should be of general nature and the same law should apply to all persons because all persons are equal in nature, ability, or circumstances. Doesn't happen. Therefore, the principle of rational classification has been adopted. Therefore, the state can discriminate between individuals on the following grounds: on the basis of geographical conditions, discrimination in favor of the state, tax legislation, for the protection of tribals in the interest of public health, on the basis of education, special courts and special procedure, classification of criminals into juveniles and other criminals. Apart from this, in some circumstances a person can be considered a class. Let us write a short note on the doctrine of eclipse. The principle of concealment or eclipse is based on subsection 1 of Article 13 of the Constitution. According to Article 13(1), pre-constitutional laws will be invalid after the implementation of the Constitution to the extent that they are inconsistent with the fundamental rights. Such laws are not void to initio, but after the fundamental rights come into force, they almost become dead and cannot be enforced. Such laws do not disappear at all. They only get covered by the fundamental rights and remain dormant. Their existence remains valid for all the transactions before the implementation of the Constitution, and the rights and obligations acquired under such law remain the same. Can such methods be reintroduced to solve the problem? The Supreme Court had propounded the principle of coverage in the case of Bikaji versus State of Madhya Pradesh, EIR 1955 SC 781. In this case, a pre-constitutional act, the Barrett Motor Vehicle Act 1947, gave the state the power to take over the motor trade. The act was valid when it was made, but it became void when the Constitution came into force in 1950 because this provision violated Article 19(1)(19)(I)(z), which provides citizens with the fundamental rights in carry on livelihood, profession, trade, or commerce. But in 1951, Article 19(1) was amended by the First Amendment Act of the Constitution, and the state was given the power to create a monopoly in any business. Let us take a short break, please. Let us go through. The reasonable classification under Article 14. Article 14 of the Constitution talks about equality before law and equal protection of law. But it does not mean that every law should be of general nature and the same law should apply to all persons because all persons are equal in nature, ability, or circumstances. Doesn't happen. Therefore, the principle of rational substitution has been adopted. Therefore, the state can discriminate between individuals on the following grounds. We have discussed it. Now, abolition of untouchability. Article 17 of the Constitution provides that untouchability is abolished and its practice in any form is prohibited. It is an offense to impose any disability arising out of untouchability, which will be punishable as per law. Thus, Article 17 abolishes untouchability and prohibits its practice in any form. It makes it a punishable offense to enforce any disqualification arising from untouchability. In this way, the Constitution not only ends the stigma that has been prevalent in the Indian society since ancient times, but also prevents it from being followed in the future. It is the exercise of its power under Article 17. The Parliament passed the Offences of Untouchability Act 1955 in 1955. It declares untouchability as a crime and provides for punishment for it. Now the name of this act has been changed to Protection of Civil Rights Act 1955. Under this, it will be the duty of the public servant to investigate the said crimes and take appropriate action. If any public servant willfully neglects to investigate the offences committed under this said act, he will be deemed to have abetted the commission of such offence. It is noteworthy that untouchability has not been defined in Article 17 and the said act, but Mysore High Court has clarified its meaning in one of its decisions. The court said that this word should not be construed literally in literal sense. Persons can be considered untouchable due to many reasons like untouchability arising due to birth, marriage, death and other reasons. Its meaning should be understood from those social evils which have developed traditionally in the context of caste system in India. This article addresses the evil of this caste system. In the case of Pupils Union for Democratic Rights versus Union of India AIR 1982 SC 1473, the Supreme Court held that the fundamental rights conferred by Article 17 are available not only against the state but also against private individuals, and it is the constitutional duty of the state to he should take necessary steps to prevent violation of these rights. Abolition of titles. Article 18 of the Constitution provides for the abolition of titles. This article provides that the state will not confer any title except military and educational honors. No citizen of India shall accept any return from any foreign state. No person not being a citizen of India holding any office of trust or profit under the state shall, without the consent of the president, accept any title from any foreign state. No person holding any office of trust or profit under the state shall accept any gift or emolument or office in any form from or under any foreign state without the consent of the president. Therefore, it is clear that Article 18 of the Constitution prohibits the state from granting title to any person, whether a citizen or a foreigner. This article puts an end to the feudal tradition that had been going on since the British rule in India, but allows the granting of military or educational title because they help individuals to strengthen the military power of the country and develop the scientific equipment necessary for the country's progress. In the case of Balaji Raghavan versus Union of India 1996, 1 SCC 361, the Supreme Court, although declared the power of the central government to confer national decorations, Padam Vibhushan, Padam Vibhushan, Padam Shri as constitutional, but at the same time, it also said that government cannot award the said decorations. It has failed to exercise adequate control in providing in this case the petitioners prayed to the court to stop the government from giving such decorations. His argument was that these declarations are titled under Article 18 and hence they cannot be given. The court ruled that the above declaration is not a title under title used under Article 81 and it cannot be used by any person before or behind his name, suffixes or prefixes. The five-member bench said that the guidelines given for awarding these decorations are very broad, indefinite, and can be misused. The court had suggested that a high-powered committee be appointed by the Prime Minister or in consultation with the President to investigate all aspects of it. The court made it clear that the number of such decorations should be limited. Justice Kuldeep Singh, in his judgment, pointed out the misuse of these decorations and said that they have been given even to many businessmen and industrialists who have not made any contribution to the national interest. The present process of doing so is flawed. The justice suggested that the Prime Minister, on the advice of the President, should set up a committee at the national level consisting of the Speaker of the Lok Sabha, the Chief Justice of India, and the leader of opposition. Similarly, similarly, a committee should be set up at the state level, also in the name of those persons. Make recommendations which should be approved by the national committee. The recommendation of the committee must be approved by the Prime Minister and the President. The said decision will be helpful in preventing devaluation of these ornaments. There is no provision of any punishment in the Constitution for those who violate the provisions of Article 18. This article is only directive, not prospective, but the Parliament has full power to make provisions for punishment for those who violate these provisions by making a law. Parliament has not yet passed any such law. In Indra Jaisik versus Supreme Court of India, AIR 2017, SC 50/117, it was held that designation of senior advocate is a distinction and recognition and not a title. This type of designation is used to recognize the person's talent and special qualities which are found in other professions also. The exercise of the power of designation of senior advocate by the Supreme Court and the High Court is limited by the requirement of the concerned advocate to fulfill the three conditions stipulated in Section 16 of the Advocates Act. One is qualification. One is qualification to his legal standing, position in bar, and or three is the person making the request have special knowledge or experience in law. The possibility of misuse of power cannot be the basis for holding the provisions constitutionally weak. The Supreme Court issued instructions to handle all such designation in the Supreme Court and the High Court by a standing committee known as the Committee for Designation of Senior Advocate. Article 17 of the Indian Constitution abolishes untouchability and prohibits the practice of the same. Let us explain in detail. Article 17 of the Indian Constitution, which forms part of the fundamental rights, provides that all forms of untouchability are abolished in the country and they are practiced in any form. They can become the basis for legal action. The word in any form is used in an inclusive way, meaning that any and every form of untouchability is forbidden. Thus, not only is treating the untouchable community with disgrace, with such forcing them to live in separate areas, prohibited, but also the ceremonies of purification that were observed for coming into contact with such people should be abolished. Surya Narayan Chaudhary versus State of Rajasthan 1988. This case across is the backdrop of a discriminatory practice that was involved in Srinathji temple at Nathdwara, Udaipur. where Harijans were allowed to enter the temple premises only after observing certain purification ceremonies like being made to wear kanthi mala and having Gangajal sprinkled upon them and being given tulsi dal according to the petitioner, who was himself the learned advocate in the case. Such practices amounted to the propagation of the practice of untouchability against the Harijans and were a violation of the constitutional mandate which expressly prohibits such practice. The Rajasthan High Court, while taking cognizance of the matter, expressed its disappointment that untouchability still continues to be prevalent in our society. Despite several measures taken by the government and efforts made by social reformers to erase the heinous concept of discriminating against persons on the basis of caste, the court pointed out that simply enacting laws against untouchability do not serve its purpose when we ourselves do not believe in saying that all men are born free and equal. It is high time that we discard such an orthodox mentality and embrace the citizens of our country with equality and a sense of brotherhood. The High Court directed the state government in this matter to ensure that all persons, including Harijan, are granted access to the Srinathji temple. It also ordered that Harijans should be allowed to enter the temple without requiring any special rituals to be observed by them that are not applicable to other devotees. The Srinathji temple, being a place of public worship, cannot impose any discriminatory practices that are to be made applicable to the Harijans exclusively, as it would be violative of Article 14, 15 and 17 of the Constitution. Let's explain the right to privacy. It is generally understood that privacy is synonyms with the right to be left alone. The Supreme Court in the year 2017 in the landmark decision of KS Uttaswamy versus Union of India described privacy and its importance. According to According to the Supreme Court, the right to privacy is a fundamental and inalienable right, and it includes all the information related to the individual along with the decisions taken by him. The right to privacy is protected under Article 21 as an intrinsic part of the right to life and personal liberty and as a part of the freedoms guaranteed by Part 3 of the Constitution. This right can be restricted by state action only if they pass the following three tests. First, there must be legislative mandate for such state action. Second, it must pursue a legitimate state objective. Third, it must be reasonable. That is, such state action must be proportionate in nature and extent necessary for a democratic society and must be the least intrusive of option available to achieve an objective. Steps taken by the government to protect privacy. VN Shri Krishna Committee. The government appointed a committee of experts on data protection headed by Justice B.N. Krishna, which submitted its report in July 2018. Information Technology Act 2000. The IT Act provides protection against certain breaches with respect to data from computer systems. It has provisions to prevent unauthorized use of computers, computer systems, and data stored therein. Whether the right to die is a fundamental right under Article 21 of the Indian Constitution. Let's explain the help of decided case law. Right to die is not included in Article 21. In 1987, the Bombay High Court had held in the case of the state of Maharashtra versus Shri Sati Dubal 1987 CRLJ 743 that section 309 of the penal code under which suicide is a crime violates Article 21 of the Constitution. Therefore, under Article 21, the right to live also includes the right to die. It is illegal. Therefore, Section 309, which takes away this right, violates Article 21 and is illegal. The desire to die is not unnatural. It is only extraordinary and extraordinary. In certain circumstances, a person's life becomes a burden. In the present case, the police officer of Bombay, the constable, frustrated over the municipal corporation's refusal to allow him to set up a shop to earn a living, attempted to commit suicide by setting fire to the municipal corporation official's room. The court held that he was not guilty. As such, he had no choice, and Article 21 gives him this right. In 1994, in the case of the Rathina versus Union of India, 1994 3 SC 394, a two-judge bench of the Supreme Court held that the right to life under Article 21 of the Constitution also includes the right to die. Hence, the Indian Penal Code section 309 of the Code, under which attempting suicide is a punishable offence, is unconstitutional and illegal. The Court said that the said provision of the Indian Penal Code is cruel and unjust because it provides for punishing a person who first commits suicide is suffering from mental illness and needs counseling to cope with mental illness and does not cause any harm to others. And attempted suicide is also not against morality, religion, society, or public policy. In the present case, the petitioners against whom proceedings were being taken for the offence committed under Section 309 had challenged the constitutionality of Section 309. The court said that attempting suicide is not a crime in many countries of the world. The court followed the decision of the Mumbai High Court in the case of Maruti Shiripati Dubal. For the past many years, there had been a discussion going on in the world whether a person should have the right to die or not. But till now, scholars have not been able to reach a consensus on this, especially in view of the dangers inherent in it. It is said that it is not the right to give a person the right to end his own life. Who will decide that the un who will decide that the usefulness of a person's life has ended? The person, family, and society also have a right on his life. Subsequently, the five judges Constitution Bench of the Supreme Court in its modern decision, Yankol versus the State of Punjab, 1996 2 SCC 649, has reversed the decision given in the case of P. Ratnam versus Union of India and has held that under Article 21, right to die does not include right to die. Therefore, Section 309 and 306 of the Indian Penal Code are constitutional and valid. The right to die with dignity till the end of life cannot be equated with the right to die unnaturally by reducing the normal duration of life. Justice Shri J.S. Verma, while delivering the unanimous verdict of the court, said, any aspect of life which makes it dignified is what is contained in Article 21 and not what it eliminates the right to die, if any, is inconsistent with the right to die, as death and life are opposed to each other. The court made it clear that the right to die, which also includes a life with dignity, means a right which continues till the end of natural life. It also includes a dignified life till death, and it also includes a dignified death. It also includes the right of a dying person to die with dignity while waiting for the last moments of life at the end of life. The right to die with dignity cannot be equated with the right to an unnatural death by shortening the natural span of life. The court also rejected the argument as to whether the right to die should be abolished. The ongoing discussion on this is the ongoing discussion on this is sufficient basis that the said section violates Article 14 and is therefore illegal. This subject comes under the jurisdiction of the legislature. The justices unanimously reversed the decision in the cases of Maruti Shripati Dugal versus State of Maharashtra and P. Ratinam versus Union of India and affirmed the decision of the Andhra Pradesh High Court, which had held that Section 309 of the Indian Penal Code violates the Constitution, does not violate Article 21 and 14, and is constitutional. A short note on protection from double jeopardy. Clause 2 of Article 20 provides that no person shall be prosecuted and punished more than once for the same offense. This provision is based on the principle of English law, nemo debet vis vexere, according to which a person cannot be prosecuted and punished twice for the same offense. The Fifth Amendment of the American Constitution also provides that no person shall be again put in danger of life or limb for the same crime. But the scope of protection provided in Article 22A, Article 22 is more limited than the American double jeopardy and British common law rules. Both the above systems prohibit second trial for a crime. That is, if the person has been tried once for a crime, he can claim the protection of the rule of double jeopardy, whether he was acquitted or convicted in the first trial. But Article 22 requires that the accused should not only be prosecuted for the crime but should also be punished, and the second charge should be based on the same crime. If the accused has been acquitted as a result of the first prosecution, there is no bar on the second prosecution, even if the facts are the same. Thus, the word prosecution used in Article 20 significantly limits its scope. Article 22(2) did not apply if no punishment has been awarded as a result of the prosecution. Thus, there are three essential conditions for the prosecution of for the protection of Article 20. The person must be an accused. The prosecution or proceedings must have taken place before a court or judicial agency and must have been of a judicial nature. The prosecution should be in relation to any crime prescribed by law for which there is provision of punishment. In the case of Makbul Hassan versus State of Bombay EIR 1953 SC 325, the appellant secretly brought some gold into India, but he did not declare before the customs authorities that he had brought the gold. Customs officials confiscated his gold under the Sea Customs Act. He was then prosecuted for the crime of bringing gold into India without permission under the Foreign Exchange Regulation Act. The appellant objected to this and said that the second prosecution was for the same offence, for example, for bringing gold into India for which he had already been prosecuted and punished because his gold had been seized by the customs authorities. The Supreme Court ruled that the custom officer was not a court or a judiciary agency, nor was his order of seizure of gold under the Sea Customs Act judicial in nature, from which the rule of protection under double jeopardy would be claimed. It was ruled that he was not barred from being prosecuted under the Foreign Exchange Regulation Act. Similarly, the proceedings before departmental or administrative officers are also not of judicial nature and is not prohibited to claim the protection of the rule of double jeopardy which them self-corroboration means giving only such information which is based on the personal knowledge of the witness and not on evidence which is based on mechanical process. In the case of Vectraman Banama versus Union of India AIR 1954 SC 375, the applicant was dismissed from service as a result of an inquiry under the Public Service Inquiry Act 1961. This proceeding took place before the Investigation Commissioner. He was later charged with offences under the Indian Penal Code and the Prevention of Corruption Act. The court ruled that the proceedings before the Commissioner were not criminal proceedings but were conducted only to find out the facts, on the basis of which departmental punishment was imposed against him. Therefore, prosecuting the applicant for an offence under the Indian Penal Code was not unconstitutional. Article 22 does not apply where a second prosecution is for a different offence. Article 22 prohibits prosecution twice for the same offence and not prosecution for another offence. sentence is violative of Article 21. Let's explain. Death penalty is the harshest of all punishments and is given only in the rarest of rare cases. Reformative system of punishment has been adopted in India. Therefore, death penalty is considered the last option. In the case of Jagmohan Singh versus State of Uttar Pradesh, EIR 1973 SC 947, the question was whether death penalty under Section 302 of the Indian Penal Code is constitutional. The argument of the respondent was that since there is no reasonable procedure prescribed under the Code of Criminal Procedure for giving death penalty, it violates Article 21. A bench of 5 judges of the court ruled that death penalty does not violate Article 14, 19, and 21 because while choosing between death penalty and life imprisonment, the court acts in accordance with the procedure prescribed by law, taking into account the facts and procedure of the crime. This is done on the basis, but in the case of Rajendra Prasad, I thank all my brothers and sisters. I thank all ladies and gentlemen. I thank teacher trainers. I thank professor professionals. I thank listeners and learners. I thank all respected doctors and directors. I thank all adorable ministers and managers. I thank all honorable advocates and advertisers, administrative advisors. The most honorable President Counsellor Modi thank, thank you, thank you, thank you. Nice to see you. Have a nice day. Thank you.